Recording in progress.
It's a temporary unmuting.
I don't care, but
Quick sound check. Really, can you hear me?
Yes, we can hear you. Can you hear me?
Thank you. Yes, we can, Ms. Jackson. We have Ms. Kilby here in the Missoula County courtroom. I see Mr. Jasper appearing via Zoom. Ms. Jackson is appearing from the Mineral County District Court room. We have Mr. Leischer here in the Zoom session as well. I'm not missing anyone directly related to this case. Mr. Lance Seidel is also in the Zoom session. I've named off the parties and their counsel, the counsel that is expected to be here. I'll call the cases concurrently. Rita Mae Anderson et al. Versus Mineral County Attorney. This is DV 22-53. And Rita Mae Anderson et al. Versus the Mineral County Sheriff, DV 22-54. Good afternoon, counsel.
Good afternoon, Your Honor.
Just so that everyone is operating from the same book and page, the court has reviewed the updates that were filed by the Mineral County Attorney's Office, the Mineral County Sheriff's Office, and actually those were the two things that the court had reviewed. Were there any other items that the court needed to review prior to this hearing?
Your Honor, I don't believe from the petitioners, but I do have a question for the court before we get started.
Go ahead.
My question is with regards to the attorneys involved in this matter, when they speak to the court, does the court take that as being truthful and under oath? And if not, I would ask all attorneys at this hearing be put under oath as they speak to the court today.
So, first of all counsel have a duty of candor to the court. That is a professional duty, the violation of which could result in prosecution by the Office of Disciplinary Counsel and could affect any license of that attorney to practice law, depending on the final outcome of any ODC complaint and adjudication. The court typically doesn't need more, recognizing that the court doesn't rely on counsel for findings of fact. Those findings of fact would be done under oath and as part of testimony and as a part of witness testimony. Is an update, a status conference. Again, recognizing that every counsel has a duty of candor to the court is likely to just leave it at that.
Not this fine, just have a clear understanding. I appreciate that, Your Honor.
Okay. Again, the court had received the updates. I do know that the parties are planning to undergo a mediation with Judge Fagg. Indeed, I saw Judge Fagg, Russ Fagg, just this past week at the Montana Judges Association. I did not talk with him regarding anything specific, but he had confirmed with me that you all had engaged him for mediation, and he was looking forward to that and hadn't actually reviewed any of the information in preparation yet, so didn't have any understanding of the underlying facts for the mediation at this point anyway. I did note from Ms. Jackson's filing for the Mineral County Attorney that there was an interest in perhaps delaying this status conference until after that mediation. There wasn't agreement on that, which is fine. We can still go forward and have at least a quick update and make sure we are all on track for that mediation, and to determine what other issues remain outstanding for the county sheriff, Mineral County Sheriff, to remain involved. And I assume we'll be having some discussion about the May 22nd, 2023 letter from the County Attorney's Office But before we begin that, I will ask for any oral updates from either Mr. Jasper or Ms. Kilby.
Your Honor, I'm sorry, I came in a minute or so late, and is Mr. Congdon present?
He is not.
So,
Ms. Jackson is.
okay.
Is she, I'm sorry, Your Honor, but is she for the record now representing the county? Because it's always has been represented that Mr. Condon is going to be the attorney for the county.
Your Honor, would you like me
Well,
to
before
address?
Ms. Jackson, before you answer, I will say this, that Mr. Congdon repeatedly spoke for the county attorney's office, and in fact, I think there was some issue about him being left off receiving particular notice of something that had actually gone to Ms. Jackson rather than him directly. It is my belief that Ms. Jackson, as a practicing attorney, may represent the office as well as Mr. Congdon. And so I have no preference as to who appears on behalf of the Mineral County Attorney's Office, only that someone appears on behalf of the Mineral County Attorney's Office. Ms. Jackson, I don't know if you have anything else to add.
No, Your Honor, I believe that Mr. Congdon was under the impression that the meeting was going to be continued. I think there was discussion on that. He committed himself to another mediation, and there's probably 6 or 7 attorneys involved in that. And so I'm appearing because he hasn't been able to make it. And when we talked to Mr. Leisher, he was unwilling to continue unless we signed the stipulation, and we were unwilling to do that. So he had previously committed himself with the understanding that we thought it was going to be continued. So I apologize for that.
Okay. I will return to Mr. Jasper or Ms. Kilby to give an update on petitioner's position with regard to any of the outstanding issues, and we can discuss either the Mineral County Attorney's Office first or the Mineral County Sheriff's Office, whichever you wish.
Thank you, Judge. I don't believe we were served with the update from the county attorney's office that was filed, so I'm not familiar with that, but if there's anything substantive in it, I was trying to pull it up and I'm having internet problems. I can address that hopefully later. We don't have an update at this point other than the fact that we have our mediation scheduled for Friday. I do believe that Mr. Leisher has some issues he'd like to bring to the court with respect to that. I have made several attempts to get this moving forward, and I think I'm hopeful that we're, with respect to Mr. Funk, we are on the right track. I know we are. To Sheriff Funk, I'm asking that the court release him from the writ. I've asked that several times as the petitioner, and I think Mr. Leisher will be able to speak to that more, and then I can kind of follow up on some of the things that he has to say.
So, Ms. Kilby, just so that you are aware, the update or the brief statement that Ms. Jackson gave was essentially the update to the court advising that a mediation is scheduled before Judge Fagg on May 26th, and some discussion about potentially 9 issues that the parties are attempting to resolve at that mediation, and then also that there was an attempt to get a stipulation to continue today's status conference. And so that was really all the update was. It did include under seal a copy of the May 22nd, 2023 letter, which again, I assume we'll be speaking about here shortly.
That letter was also, I'm sorry, Your Honor, that letter was also emailed to Mr. Jasper and Ms. Gilby. I believe it was emailed as well to them. So.
I received the letter, Judge.
Oh, okay, very good.
but just not the update.
Okay, thank you.
Thank you for that. I don't have anything in response to that then.
Okay. I'll leave Mr. Leisher up to the last. Ms. Jackson, do you have an update from your perspective or anything more just to provide other than the update provided?
No, Your Honor. I think the court probably is aware of my concern that it did go out without seal, so I'll let the court address that as needed.
Fair enough. Mr. Leisher.
Thank you, Your Honor. What I'd like to address today was what I perceive to be a very simple order from the court at our last hearing on April 21st, which was for the county attorney's office to provide the sheriff and the petitioners with any remaining compliance issues regarding the writ of mandamus that the court issued last October. And I sent 2 emails after the hearing asking for those items and was told that they were being worked on, but we never received anything. And, we also heard very clearly from the court that he wanted us to cooperate and resolve the issues amongst ourselves and be grown-ups. And we're trying really, really hard to do that, Your Honor, to the point that Ms. Kilby, counsel for the petitioners, went so far as to schedule a meeting with Mr. Condon in order to get the county attorney's office to finally commit to which issues it believed remain outstanding before the sheriff can be released from the writ against the sheriff's office. And the product of that meeting was the first letter that I attached to the status update, in which 2 issues are identified. And those are issues that fall under the writ and are dead on point, and we addressed them. And after those were resolved, which we resolved quickly, you'll note that letters dated May 12th. It took that long to get the county attorney's office to commit to what the issues were. And we were told repeatedly that Mr. Condon would be the one responsible for deciding those issues, that the ball was in his court on this. And those issues were resolved, and when I spoke with Mr. Condon, he assured me that the resolution that the sheriff's working in conjunction with us, offered as proof that those items had been completed, was acceptable. And so I asked if we could then please dismiss the writ against the sheriff's office, and was told no. And when I asked what remaining compliance issues they were, I got word salad, Your Honor, that went all over the map and largely centered around this issue with the mental health evaluations, which has become something that the county attorney's office is very stuck on. And for a brief history, after the petition for the writs was filed, former Sheriff Toth, working with the county attorney's office, one of the original issues being that the deputies had never had mental health evaluations done, went and obtained mental health evaluations. The problem is they were obtained from a physician's assistant, and 7-32-303 requires that those be conducted by a physician or a mental health, licensed mental health professional. So those were non-compliant. Now, in our first meeting after the sheriff hired us to represent him with Ms. Kilby as counsel for the petitioners, Ms. Kilby pointed that out to us. That was the first news that the sheriff had of it, or that we had of it. And it's my fault if it's anyone's for not disclosing that to the county attorney's office. But they were aware of those because those were obtained by Sheriff Toth working in conjunction with that office. Now, Ms. Kilby subsequently, and very shortly after the sheriff learned of it, disclosed that to the county attorney's office. So there was a short period of time where the sheriff's office was made aware that those mental health evaluations were non-compliant before the county attorney's office was made aware of it. Now, this has become an issue that they simply can't get past, that the sheriff did not disclose potential Brady issues to them. I've told them repeatedly that the sheriff was relying on counsel for that it simply did not occur to me that that might be information that the county attorney's office was not able to ascertain for itself and needed to be told. And regardless, it's concluded. As soon as Ms. Kilby informed us of that, we had the sheriff go and obtain compliant mental health evaluations. Both the petitioners and the county attorney's office have signed off on those mental health evaluations, that they're compliant. There's no question they're compliant. That issue is done. But we do not hear the end of it. And we have word salad coming at us with regard to what they expect to be done in order for the sheriff to be released from the writ. And the reason I'm bringing this to the court is because at this point, two things have become clear since the last hearing. And the first is that the county attorney's office, I do not think, is capable of giving us a simple list of which deputy and which statutory requirement they believe is non-compliant. What we're getting instead is this very vague and broad argument that the writs have to do with anything that the county attorney's office believes that they have to do with and are not confined to their express terms. At this point, we don't have much hope that the county attorney's office is going to be able to give us a list that we can comply with. And the substance of the May 22nd letter that we also attached to our status update, you'll notice is predominantly characterized by the county attorney's complaints about perceived slights or bad acts from the sheriff's office that don't have anything to do with compliance with the writ, with the potential exception of Mr. Allard. Much like this court's request or order to the county attorney's office, that it provide the sheriff with exactly what remains to be compliant. I've repeatedly asked over the past 8 weeks that they provide me with something in writing that explains why they believe Mr. Allard cannot be hired, and I have yet to receive that. It's to the extent that they're willing to talk about it on the phone, what I'm told is simply that Ms. Jackson believes that he is a Brady cop, and that she would, mind you, there's been no judicial determination of that. She believes he's a Brady cop, and she does not want the extra work of having to disclose Sheriff Toth's investigation of Deputy Allard. That's it. When I ask if there's anything further, I'm told that they will review the files and see if there's anything else. When I tell them that, whether or not Mr. Allard is subject to Brady disclosure is a matter that requires judicial review, and that we could ask the court to decide that, they sidestep and avoid that and have no interest in any final determination of that issue, much like they do not appear to have any interest in a final resolution of the writ against the sheriff's office. I wanted to keep this status conference, even though we have not yet completed the mediation, because what the interactions with the county attorney's office have led me to believe is they're not getting the message that the way they approach these writs is causing problems. That it's delaying and obstructing the ability of the parties who want to be done with them and to complete them, that being the petitioners and the sheriff, to get that done. And I don't think they're getting the message that they need to change course and approach these in a more cooperative manner and in a more definitive manner, where it is not a subjective matter of what they believe in any given moment, more than a month after the court orders them to tell us what remains to be complied with, to give us a very vague letter that does not address any particular subsection of the two statutes the writ covers, and does not identify any individual deputy that is not compliant with one of those subsections. I think the mediation will go will be more productive if the court lets the county attorney's office know that the manner in which it has approached these writs is not acceptable, and that the problem here is not just the sheriff preventing this from getting done. We literally can't move forward, Your Honor. We can't work with them until they get a stronger message. I thought your message at the April 21st hearing was very clear and very strong, and I don't think the county attorney's office heard it.
Thank you, Mr. Leisher. Ms. Jackson, I'll give you an opportunity to respond, if you wish.
Thank you, Your Honor. First of all, my conversation never included that the sheriff is a Brady cop. Secondly, my conversation was requested at Mr. Leisher. He is the one that requested the May 22nd letter. He wanted to know what it was that I was seeing that I was having a hang-up with. My hang-up, Your Honor, is not looking at the letter that's on the page. It's looking at the spirit of what the writ is behind. It is to kill the Brady Giglio requirements for Mineral County to have to keep disclosing, spending time, spending cost, spending finances, spending all of this to disclose things that should have been taken care of way long ago. We're attempting to put policies and procedures about this so that we can go ahead and know specifically that the information is coming to the county attorney and we can decide what we need to disclose. The county attorney is the one that has to do all of this. We're the ones required. We're the ones that are imbued with the knowledge, even though it doesn't come to us. We are the ones on the hook. So we have to have confidence that we've got policies and procedures where Brady Giglio information is not buried and is provided to us so that we can provide it to the other counsel that's out there. I understand Mr. Leisher and Mr. Jasper are concerned that we're not releasing everything, and the sheriff from the writ. I get that. But the reason we're not is because the confidence level that I have that I'm getting everything is not there. As the court knows by, this letter Mr. Leisher asked for, I just tapped out in about 10 minutes. This is not all-encompassing. This is just to show what the Brady Giglio issues are. Do I have to respond to the fact that PAs saw the mental health evaluations instead of a licensed physician? I don't know. Do I have to disclose all of that? You know how many attorneys? I think the court does. You've seen the expando full of disclosures that we have completed and done. I am very adamant about getting the Brady Giglio done so the taxpayers of Mineral County don't have to pay for it anymore. And the problem is, every time, I keep hearing it's our fault and we're just not releasing it and we're just being unreasonable and we have no intention or interest in resolving the matter, is hogwash. It is absolutely hogwash. What we're trying to do is prevent this in the future. The court doesn't want us coming back with another Brady Giglio. I don't want it on my backside. And I'm the one responsible. I'm impugned with the knowledge. I need to have the confidence that I'm getting all the information when it occurs and how it occurs so I can disclose. The risk and the liability for not doing so is great. And I know it. And the court knows it. As a county attorney, any county attorney would know it. It's one of the reasons I took the position, because I was disclosing. May 13th, I started out appointed. By June 6th, we started disclosing. And I don't want to end. I want it to be fulfilled. I want the fruit of this writ to be completed. And I'm sorry it's inconvenient, but I'm willing to work with anybody, anytime, that has the same goal of protecting Mineral County. And I don't appreciate and do not appreciate saying that I just don't want to disclose TOS investigation. I have disclosed TOS investigations. The only thing I have not received is the internal investigation on Nobles. I have disclosed it. And that I'm calling the Sheriff a Brady cop. I am not. I did not say that to you, Mr. Leisher. I did not. And I'm frustrated that we have to pick at each other rather than work with each other. And I'm frustrated that this writ of mandate, all the hell we're going through, has not been for nothing. I want to make sure we accomplish what we set out to do. We give guidance in the procedures, and we give the confidence back to the taxpayers. This is not how we do it. By sitting here picketing at each other and saying, take her to the woodshed so she reacts the way you want her to react at a mediation. I think that's improper. And you know what? I'll submit to the court. I'm sorry for losing it, but enough is enough.
So let me,
Your Honor, I'm sorry.
yes,
Would like to address the county attorney's comments when appropriate.
I will allow that, but I'm first going to address some issues. So, first of all, in looking through the May 22nd, 2023 letter, there are matters that are related to the writ, and then there are matters that are related to the interrelationship between the Missoula County Sheriff, or Mineral County Sheriff, the Mineral County Attorney's Office, and of course the Mineral County Commissioners. And in looking through these matters, and I'm going to go the paragraph by paragraph. Paragraph number 1, I know the issue of the hiring of Mr. Allard has been a hot button issue. I will say I believe it is a policies and procedures issue in Mineral County. I do want to correct the county attorney slightly, which is the court is interested in making sure that any Brady Giglio information is properly disclosed, and where it was not properly disclosed in the recent history, that disclosure or lack of disclosure is remedied. The court makes no opinion, Ms. Jackson, on whether there should just never be any Brady Giglio information to disclose. I recognize it is a burden, and I agree with you that it is a burden on the county attorney's office. But that burden needs to be resolved as a matter of hiring practices between the three parties I previously indicated: the county attorney's office, the county commissioner's office, and the county sheriff. Because if a otherwise qualifying officer is properly hired by the sheriff and comes along with that individual, Brady and Giglio disclosure, that Brady Giglio disclosure must be made because a defendant has the right to attack the credibility of any officer who has taken a significant role in the investigative process for that case. And that is the clear requirement of Brady Giglio. However, the court's writs were not directed at seemingly stamping out any requirements, future requirements, for the county county attorney's office to have to disclose that. I recognize that there may be peace officers in the state who come to the county with some baggage that does not disqualify them from serving as a peace officer, but comes with an added requirement of disclosure and comes with a potential for credibility issues on the stand. Again, Ms. Jackson, I certainly don't endorse the sheriff's office hiring those individuals. I certainly understand the added impact on your office and am sympathetic to that. But again, that was not the goal of the writ of mandate. The writ of mandate simply requires the sheriff's office to do three things. And those are to audit its hiring practices and report to the court which peace officers have not met the statutory requirement for duty. 2, to remove from peace officer duties all deputies employed by the Mineral County Sheriff who do not meet the statutory requirements until such time as the statutory requirements are met. And 3, that the Mineral County Sheriff shall follow statutory mandates for hiring proceeding forward. And again, if those are satisfied, then the sheriff should be released. In reviewing this letter, again, the court perceives paragraph 1 as an issue regarding hiring process and procedure. And that must be resolved between the 2 or 3 offices, as the case may be. As to paragraph 2, again, I see that as an internal hiring practices issue. I would assume the county, for instance, may adopt policies and procedures to help limit or eliminate Brady Giglio disclosure requirements through the hiring process and making certain that deputies don't come along with onerous baggage. But again, that is where the parties must work together to come to an agreement and to come together on a hiring practice and procedure. Again, recognizing that it is the sheriff who has the hiring authority in the end, and it is the county attorney who has must make the determination on prosecution if it believes that it cannot prove to a jury beyond a reasonable doubt that a defendant is guilty of one or more criminal acts. It is up to the county attorney to say, I can't trust testimony from XYZ deputy and make that determination. But again, that is not necessarily a statutory issue or a direct issue implicated by the writs of mandamus. Paragraph 3 relates to the physician assistant review and evaluation. I do note, and I think everyone did recognize at our last hearing, that the physician assistant evaluation was not statutorily compliant, that I heard the sheriff or counsel indicate that subsequent to that, they have all undergone appropriate evaluations and are now compliant. I believe I even said at that particular hearing that I suppose if there was a need for a specific declaration, perhaps the court could make that. But it seems to me that if the first evaluations were non-compliant, but the second evaluations were compliant, that simply noting the period of time that they operated under non-compliant physician assistant evaluations and noting that they had passed subsequent physician evaluations may be sufficient for disclosure, but I leave that to the county attorney's office to determine that since it's their obligation, and I do not give an advisory opinion on that issue. Then finally, there is the paragraph 4, and this is the part that I am uncertain about because it appears that there has been there has not been a free and appropriate flow of communication and information between the two offices, the county attorney's office and the county sheriff's office, which is the audit hiring practices review and to determine whether reserve officers have met statutory requirements, dispatchers their statutory requirements, and detention officers have met their certifications to date. I see that as one outstanding piece that legitimately has been raised by the county attorney's office and would necessitate further inquiry because that is implicated by the writ, which is paragraph 3 of the writ that commands the Mineral County Sheriff to follow statutory mandates for hiring proceedings forward, and that was not simply restricted to peace officers, but rather it was to all hiring proceedings forward. Now again, the court is not ordering the sheriff to comply with county policies and procedures. That's an issue, again, internal issue from the court's perspective. This is statutory mandates, and the court is holding the sheriff to those statutory mandates, period. And so I think, Mr. Leisher, it would be helpful for the court to have a certification from the sheriff to all three matters have been completed, signed by the sheriff under oath, and a description of the items and how they were fulfilled. And it can be a very brief certification. It does not have to be incredibly lengthy. I'm thinking 2 or 3 pages at the most. I don't need detail as to absolutely every officer, as long, if there is a specific individual that needs to be identified or something like that, I'll leave that to the sheriff to provide that level of detail. At this stage, the court is not going to release the sheriff until that certification is in place. I also have a desire to see the sheriff participate in the mediation by Judge Fagg, because I do think that there are issues beyond the writs that could use mediation between the county attorney's office and the county sheriff's office, and I want that full and complete participation, at least in that mediation on Friday. Upon receiving the certification, however, the court is going to give the county attorney's office 1 week to respond to that certification, as to any items, again, in the same sort of laundry list fashion that the county, that I'm hoping the county sheriff's certification will be in, to determine what items have not been completed, and then the court will take that matter as fully argued by the parties, and will make a determination as to whether the sheriff should be released. Likewise, Ms. Jackson, I am asking the county attorney's office to provide a similar certification related to its writ of mandamus, to identify in a laundry fashion what items have been completed and what items have not been completed and still require further action. And then specifically a request for what sort of additional time is reasonably believed to be necessary to complete any incomplete items. With that, Mr. Jasper.
Your Honor, I would just like to address a few matters raised in the May 22nd letter with regards to paragraph number 1 regarding Micah Allard. This court's well aware of the fact there was multiple allegations of misconduct by myself in the sheriff and obtaining the mental health evaluation from Dr. Stratford. Dr. Stratford, because I represent almost all of the law enforcement officers in the state of Montana that are involved in the officers involved shootings, inadvertently placed my name on the bill. That was a situation where all I did was told the sheriff who qualified to do a fitness for duty evaluation, and he went and obtained the Mike Allard fitness for duty evaluation. Also submitted a letter to the sheriff, which was obviously to be shared.
I've heard this before, so.
I know it's really important, Your Honor, if I can just continue for a second.
Well, jump chase.
All right.
You're laying facts that I'm already aware of. I think you can just jump to the chase.
So the chase of it is, Your Honor, with regards to paragraph 1, the county attorney has been aware of the Mr. Allard situation, has claimed this same information, and has been made aware from the very beginning that if she considered it a break situation, to bring it before the cop, or before the court, and that's not been done, and as such, it's a purposeful delay. With regards to number 2, paragraph number 2, which is very important, if the court was to go back to the record, there has been repeated representations by the county that policies were being drafted had not been provided to them. One is that was a direct lie to the court. The policies existed, were in place, and when new counsel for the sheriff took over, we were able to see them. And so with regards to the hiring policies referenced in number 2, those simply were never provided not only to us, but the court, and is a figment of imagination because they could have been provided earlier onto it, negating the plaintiff of writ of mandamus with regards to the sheriff for sure. With regards to mental health evaluations, which have already been discussed, but the county attorney's office, working with Sheriff Tom, completed these mental health evaluations without reviewing the statute, and the sheriff simply went in and completed them after a review, realizing that they weren't in compliance, completed those at no fault of the sheriff's office. The last thing I wanted to talk about last court hearing, this court made it clear that there would not be attempts to attack either myself or the sheriff in this matter. And I have received information that the county attorney's office has reached out to the press, including the name of the individual as Monty Turner, requesting that they do a negative story on the sheriff's office and myself. And that is part of the reason I asked early on is whether we were under oath, because I want to know if they violated what you told them when we were at the hearing last time by contacting Monty Turner.
So Mr. Jasper, again, I think what you're asking for is some sort of opportunity for an evidentiary hearing. I respect the right to have that. I would have you tee it up. It appears you have specific information. I would tee it up with a motion supported by an affidavit from Mr. Turner, indicating that the instruction I had previously provided the parties was not followed, and request that someone may be held in contempt of court for failing to follow the instruction, and we can address it that way and have potentially a show cause and evidentiary hearing. But I don't know that starting down the road of evidentiary hearing in the midst of a status conference is going to be a productive use of our time.
I don't disagree, Your Honor, but again, when you tell me something, I take it as the gospel. And if I'm just frustrated because the intention of the petitioners here is nothing more than to try to get the county attorney to comply with the law on it. It's not something that neither Jordan or myself ever wanted to be involved in. And the second thing is that when the court's orders are just simply ignored, it has the effect of making things ineffective. So one, I would ask the court to reiterate that part, because I certainly myself have held myself back from making my own statements regarding this matter. And then the last thing is, I believe in the previous order the court made that it was going to order a supervisor for the county attorney's office, and I think that that needs to occur sooner than later.
Your Honor, could I just follow up on one thing with respect to that?
You may, go ahead.
So, Judge, I wasn't here for the last hearing, but I did try to listen to some of it on Zoom, and it was very clear, the court's order. And the court's been very clear throughout this entire process about what it expects of the county. I echo Mr. Lakeshire and Mr. Jasper's frustrations. The court issues orders, and the county attorney's office does not follow them. What happened in this, what has happened historically, we had the order about the personnel files, and then they weren't disclosed, right? We had the order about within 1 week, you will provide to the sheriff's office a list of things that they need to do to complete their part of this. That doesn't happen, and so in all of these cases, Your Honor, I have reached out to Mr. Conlon. He came into my office, sat down with me. I have gone out there, and we have gone through this step by step about what needs to be done. And this last time, they ignored the court's order. They did not send a list to Sheriff Funk. And so we sat down and went through it, and I was very clear, is this what needs to be done? Does this meet what the court has ordered you to disclose to the sheriff a list of things that they need to do? Yes, said Mr. Compton. I put together the letter, I sent it to Mr. Leisher, and I think we're all just here frustrated, and I understand the court's order that there's still things outstanding and that those are valid, and I've already drafted an email to Mr. Leisher. We will work on it. But part of the problem is that the court issues an order. I don't know if it's misunderstood. Mr. Leisher and I spent a lot of time trying to figure this out, how to actually make progress in this case. And we're all just extremely frustrated with the fact that the court can issue an order and the petitioner, the county attorney's office does not follow it. And I've had to do a lot of extra work, and unfortunately, I think it is going to end up being costly for Mineral County, which is the last thing that I actually want for Mineral County. I didn't review all of the detention officers' files because I think I expressed to the court how disorganized they all were, and it took me forever just to get through the deputies. I'm hoping that the sheriff and I can work closely to get that done soon, but I do think it's important, despite everything that Ms. Jackson had to say and the way she said it today, that the court reiterate to her that this is not personal, that the sheriff is actually trying to come into compliance with everything that he's supposed to be doing. I wouldn't say that if that was what I had seen throughout this process, and that we need to move forward. There's all of this talk about the mental health evaluations weren't disclosed to us, and it as if that was done with some malice. I think that if the court could just reiterate to the county attorney that we are not here to attack her personally, we are just trying to move forward with this, and we can't do our jobs if she doesn't do hers, and so we need her to follow the orders of the court. And then the other thing I had, Judge, was I have all the personnel files. I don't know if those have been disclosed to counsel for the sheriff. Although the protective order includes parties, every time I bring it up, I hear that we need to amend it to include the sheriff. I would just like the court to allow me to give those to Mr. Leisher so I'm not saddled with looking through each of them and trying to figure out who's in compliance where.
Your Honor, I apologize, just there may be a couple of quick facts that would help you understand with the files. So HR maintains those, the Sheriff's Office does not. We understand from Ms. Kilby that they were a mess. We have offered to the County Attorney's Office and to the Commissioners that the Sheriff is happy to take responsibility for all of those personnel files and to make sure, exactly like you suggested at the last hearing, that there be a checklist and each of the documents that shows that all the statutory requirements are met for each deputy. We've offered to that. It's not one of the things I've sent 2 emails on and got no response. And we're absolutely, we will help Ms. Kilby. We will work through, this is just the first we've heard of anything to do with the detention center. In the 7 months this has been going, it's never come up, which is why the timing was so disappointing, and more than a month after the order to tell us what remained to be done. We're absolutely going to do it. We will need to be able to see those personnel files, though. They never served copies on us, and we don't have them. So that would be immensely helpful for getting that resolved if we could be, if the court could determine that we're within the protective order for those personnel files, so the county attorney's office will let us see them.
So, to be clear, it is the intention of the court that the sheriff's counsel which the court has previously indicated is Mr. Lance Seidel and Mr. Leisher, and who have been appropriately retained by the sheriff, should have access to all personnel records related to the sheriff's office, so that counsel can assist the sheriff in responding to the writ of mandamus. It doesn't seem to me to be particularly confusing as to whether counsel should have access to it. Counsel are acting on behalf of the sheriff and should have all of the access that a sheriff should have, absent it creating a security issue. For instance, I wouldn't presume that Mr. Leisher or Mr. Lance Seidel would be walking up and down the detention facility corridors among inmates of the Mineral County Detention Facility. That's a security issue. But having access to personnel records is an absolute necessity in order for the sheriff's office, through its counsel, to comply with the writ of mandamus. So yes, Lance Seidel and Leisher shall have access and is encompassed within the protective order, period. Mr. Jasper, in response to the order for a supervisor, the court has considered that. The court is ready to appoint. I wanted to see what would happen through the mediation. And it is still the court's intention to see what happens through the mediation, to see if progress can be made. The court notes that the supervisor may come at a cost to Mineral County, and I am mindful of saddling Mineral County with any more fees and costs than a small rural county should have to bear. It is my intent, however, that the county sheriff and the county attorney shall abide by the mandates within the writs of mandamus. My patience is waning. I will direct the county attorney to be mindful of any orders, written or oral, provided in this court, and that the office is treading on thin ice by not punctually and fully complying with orders of the court, whether written or oral.
Your Honor, may I say something? The court just listened to all these allegations from Mr. Jasper and never gave me a chance to respond. You're just assuming that they're true. This is not.
So I have not, if you've noticed, Ms. Jackson, I have not commented on whether they are true or not. I have simply said that the county attorney, much like any party, but most of the orders have been directed to the sheriff's office and to the county attorney's office. To the extent that I issue an order to petitioners, they must punctually and fully follow the orders of the court, whether written or oral. I have not indicated that you have violated any rules at this point or orders at this point. I've simply provided instruction that your office, as well as the sheriff's office, need to follow the written and oral orders of this court, period.
We have.
Then I will say, again, if there is a question that can be brought to the court's attention through a motion, an affidavit, providing information that would show that there have been violations, and the court will take it under consideration. Again, I rely upon the parties to work together to get these matters resolved. The sooner it's resolved, the sooner that the writs of mandamus can go away, and the parties can get about doing the people's work, which is really what we're all here for. At least from the standpoint of the county attorney's office, the county sheriff's office, the county commissioners, and frankly, the office of this court as well. So I do want an update on the status of the mediation that is to take place on the 26th. The court would like that by the following Friday, June 2nd. You may either come together and have a stipulated report to the court, or you can submit your own reports. I'll leave that up to you. The court is going into, frankly, 3 weeks of trial. The soonest I would be able to have a status conference would be on Monday, the 26th. Are the parties available for a status conference at 1:30 on Monday, June 26th?
I am Judge Jordan Kilby.
I can't speak for Wally Conklin, but I believe so.
Likewise, Lance Jasper unavailable.
Your Honor, counsel for the sheriff is available as well.
Okay. Again, before that date, frankly, the sheriff may or may not be released. I am waiting on two things. One, the outcome of the mediation report, and secondly, the certification of the sheriff and any objection by the county attorney or petitioner. I need a certification again from the county attorney's office as to the status of their compliance with the writ. Both certifications ought to be filed no later than, I'll give you till June 16th. Of course, you can always file it sooner. Is there anything else we need to address?
Is all previous order in effect?
All previous orders continue.
Thank you.
Okay. Thank you all. We are adjourned for the day.
Thank you, Judge.
Thanks, Judge.